Good afternoon and welcome to today's presentation, Driving Under the Influence, the DUI DWI Case. In today's webinar, Mr. Dorrance will discuss what happens when a person is arrested for a DUI, what a restricted license is and how they are attained, if you can refuse a blood or breath test, what are some common mistakes made by officers regarding DUIs and DWIs, what is the rising alcohol defense, and how many types of field sobriety tests are there. To give you a little background about our presenter, Stanley Dorrance, he is a graduate of the University of California at Berkeley, where he received his Bachelor of Science Degree in criminalistics. Prior to founding Forensic Science Services, Mr. Dorrance was a Criminalist 3 for the California Department of Justice, Bureau of Forensic Services from 1972 to 1982. He was assigned to the Regional Criminalistics Laboratory in Fresno, California. Since 1972, Mr. Dorrance has qualified as an expert witness in over 3,500 alcohol-related civil and criminal cases. Mr. Dorrance is also a National Highway Traffic Safety Administration field sobriety test instructor. Attendees who require a passcode, the word for today is drive. During the Q&A session, we will ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. You are also required to complete the survey at the end of the program. Please note that CLE credit cannot be given to those who are watching together on a single computer. Tomorrow morning, we will be sending out an email with a link to the archive recording of the webinar. The slides can be downloaded from the resource list to the left of your screen. Thank you all for attending today, and Stanley, the presentation is now turned over to you.
Thank you. Showtime. Today we get to talk about a pretty common event, driving under the influence. I certainly understand that many of you do these on a regular basis, so some of the information I have will be relatively rudimentary. For those of you who do not do DUIs on a regular basis, hopefully it will tend to show you that these cases can be dramatically more complicated than most people believe. So, with that, the first thing that I want to talk about is what is called the admin per se hearing. Most of this information will apply to everybody, but it is specific to California. The feds have mandated that this occur when a person is arrested for DUI. When a person is arrested for DUI, their license is taken on the spot. They are given a temporary license. This license is good for 30 days. If they do nothing, then in 30 days, their license is automatically suspended for 4 months. However, if it is their first DUI, well, actually, anybody can request a hearing within 10 days to contest the suspension, but it must be done within 10 days. It used to be 30 days. And they have the automatic right to a DMV hearing. I've done over 2,500 DMV hearings. Their license will remain in effect until a decision is rendered by the DMV. If it is their first offense, and they choose not to do a hearing or lose the hearing, they can request and will automatically receive a restricted license after 30 days of suspension. I'm afraid there's nothing we can do about the 30 days. In order to get the restricted license, they have to show proof of insurance, pay a reissuance fee, it's a fine, and show the DMV that they have enrolled in a DUI program. The restriction runs for 5 months and allows them to drive to and from work and on the job. After 5 months, their license is returned. The DMV hearing is a civil matter. The result of the hearing has no effect on criminal action by the DA. For the most part, the reverse is also true, but there are some exceptions to that. There are 3 issues at the DMV hearing. Was the subject driving a motor vehicle? Was the subject lawfully arrested? Was the subject driving with an alcohol content of 0.08% or greater at the time of driving? As you may suspect, those issues are frequently contested. I get involved in the third issue more often than anything else, but all three are legitimate issues. One has to understand that when you do a DMV hearing, the DMV hearing officer is a DMV employee. They are not attorneys, and many do not understand basic law. The DMV hearing officer is the judge, the jury, and the prosecutor. They have also been told surreptitiously that if they give back too many licenses, we call this a set-aside, they can lose their job. I've had 2 hearing officers in Fresno basically lose their job just for that reason, although DMV and the state will come up with a different reason. Frankly, it's an abusive system. One DMV office manager was heard to say, we don't do set-asides. I wish I was there. I would have told the lady that she's a perfect example of what's wrong with our government. The chemical test. When you are arrested, you have the choice of a blood test or a breath test. Urine is no longer a test that has to be offered. If the officer says, I'm going to take a breath test, and the subject does not object, then it is a legal, acceptable test. However, if the subject does object, then the officer must give the test that the individual requests. If it's a breath, he has to give a breath. If it's a blood, he has to give a blood. And there are reasons to do one test over the other. There's good reasons to do the breath test, and frankly, there are good reasons to do the blood test. You can refuse to take a test. However, we call that a refusal, and under California law, you can lose your license for 1 year. Just because you refuse a test doesn't mean you can't be prosecuted. You can still be prosecuted for DUI. Under the new case, Missouri versus Mcneely, the officer cannot forcibly take a blood test. They have to get a warrant. And this is becoming an issue in many states. I think there's a new case out of Texas on this. Most jurisdictions in California have been set up so that warrants can be obtained fairly quickly. And I've had a number of cases where warrants are obtained. The problem with that, of course, is that A, the blood test is, of course, admissible, and the subject is still considered a refusal by DMV, and if they lose that hearing, can lose their license for a year. The breath test is the most common test, administered 75 to 80% of the time. The disadvantage of the breath test is that it is usually administered near the time of the stop. In many cases, they also perform what's called a pass test, which is a preliminary alcohol screening device before the arrest. The subject can decline to take that test if they are told they don't have to take it. Many times they are not told they don't have to take it. Sometimes they are told if they don't take it, they will be arrested. However, the chemical test, or evidentiary test as I like to call it, has to be taken after the arrest. If it's a breath test, on average it takes about 20 minutes or less before the breath test is taken. If it's a blood test, it will generally take about 45 minutes to an hour before the blood is actually drawn. Under Title 17 of the California Code of Regulations, many rules have to be followed, particularly in respect to breath tests and, of course, blood tests. There are many factors that can affect a blood or breath test. The breath test is the most attackable of the two, and there are many issues with breath tests as to whether the individual had just consumed alcohol and was what's called in the absorptive phase, which means they could be overstating their true blood alcohol level. Are they taking certain medications which can affect enzymes in the stomach, which can cause higher blood alcohol levels, things like that. The blood test. The main advantage of the blood test is that it's usually taken an hour or more after the stop. The longer the time between the stop and the chemical test, the better, because now you're getting to the point where absorption comes into play. If the test is taken very close to the stop, then it's hard to show that someone was under the legal limit at the time of the stop if his blood alcohol level was very high. With respect to the blood, however, the key issues are, was the sample properly taken and placed in the proper type of vial with a preservative and anticoagulant? Was the sample mixed? This is required under Title 17, and mixed means the sample is inverted 8 times, simply meaning that the vial is turned upside down and right side up. That's a single inversion. You want to make sure everything is completely mixed. This does become an issue at DMV, maybe an issue at court periodically. What were the storage conditions prior to the lab? How long after the sample was drawn did it arrive at the lab, and when was it analyzed? Did the lab run proper standards and controls? I have a case going to trial right now where the sample was left in the trunk of a patrol vehicle for 8 days before it even got to the lab. And this is a retrial on a hung jury on a .19 major accident. Nobody was killed, but the defendant said he never drank anything. So this can be an issue. Okay. Officer mistakes. Under Title 17 of the California Code of Regulations, and this is violated about half the time, a breath sample shall be collected only after the subject has been under continuous observation for at least 15 minutes prior to the collection of the breath sample, during which time the subject must not have ingested alcoholic beverages or other fluids, regurgitated, vomited, eaten, or smoked. We call this the 15-minute wait. When I interview subjects who have taken breath tests, I always ask them questions about how the test was taken. It is very common for individuals to be arrested, handcuffed, placed in the back of the patrol vehicle, the door closed. The officer then goes and sets up the machine, walks to the back of the car, opens the door, administers the breath test. Clear violation of Title 17. No way was that individual under continuous observation for 15 minutes. I have a case right now out of a local jurisdiction with the body cam. I love body cams. I love cameras of all kinds. They rarely hurt us. But she is seen working on the pass test device in the hospital. She walks down the hall, turns right, turns left, goes into the room where the client is, gives the pass test, leaves, returns to the machine. Now she converts the machine from pass mode to e-pass mode, to evidentiary mode, walks back down the hall, turns right, goes down the hall, turns left, back into the room where the subject is, and administers the e-pass, or the evidentiary test. This all occurs literally within 5 minutes. However, if you read her police report, it's very clear in the report. She says, I observed the subject for 15 minutes. So you have a problem proving this. It is a legitimate issue at DMV because there's a case called Robertson versus Zolan, which basically says that if the rules of Title 17 are not followed in any respect, that's a key phrase obviously, then DMV has the burden to show that the test was administered properly. So the 15-minute wait is an issue. We do win on that periodically. However, it is pretty tough to prove. Occasionally we get lucky and we have a witness or two that was present, somebody else in the car, for example, and they're watching what's going on and they can testify that in fact this occurred. But it is an issue that we routinely explore with respect to breath tests and DMV. Okay, more officer mistakes. Under California law, you have to be under arrest before an evidentiary test can be taken, blood or breath. For example, you can't take a blood test send it to the hospital, get the results, and then use those results to make the arrest. It is not extremely common, but certainly it has happened on a number of occasions, particularly with newer officers or smaller jurisdictions, where they run the EPAS or evidentiary breath test before they arrest the subject. This is basically illegal search and seizure, and we have won on this issue numerous times at DMV. On the DMV form, in California, this is called a DS-367, also called an officer's statement. It is a document that the officer must complete and submit to DMV. Without it, DMV has no case. One significant factor is that the DS-367 is the only document signed under penalty of perjury, and I think that is significant. It is also relatively common, again for newer officers or smaller agencies, to say that an individual was stopped at a particular time and arrested at identically the same time. Obviously that can't happen, and yet this is signed under penalty of perjury. It's also, many times we have seen where for some reason the arresting officer ran the test but didn't sign the form, so the form gets signed by a different officer. Not acceptable. You can't have the test run by one officer but the form signed by a different officer. And they will frequently sign it, you know, John Joe Officer 4, and then the name of the officer they're signing it for. And again, this form is signed under penalty of perjury, which does make it somewhat more significant than the other documents. As also on this form, the officer must state the probable cause for the arrest or the stop. Why did he stop this individual? We have seen the officer say, stop for DUI and arrested. That's not probable cause. We've seen this section left blank. All right. Again, the law says you cannot use a police report, which are frequently submitted to DMV, to replace information on the DS-367. You could use the police report to clarify information, but if they don't have a probable cause, you can't just lift it from the police report and put it on the DS-367. So there are numerous things the officers do incorrectly. Retrograde extrapolation. This becomes an issue in many, many, many cases. I've done about 6,000 cases, and most of them are cases with blood alcohol levels probably below 0.14, and most of those are probably 1.2 or below. I don't get the 2.7s and the 3.5s, except on some occasionally. I've actually testified on cases as high as a 0.27. At any rate, one of the things we do here is try to figure out or calculate what an individual's blood alcohol level was at the time of driving. Obviously, we know what it was at the time of the test. But as is usually the case, individuals walk out of restaurants, bars, dinners, whatever, having just completed their consumption of alcohol. They get in their car, they drive a block, and they're stopped for a taillight that's out. So the question again becomes, what was their alcohol level at the time of driving? And like an hour later, they may give a blood test that yields a 0.10 or a breath test that yields an 0.9 or an 0.8. Then we now interview the client, find out what they had to drink and when, and then we use a computer program to try to calculate what their alcohol level was at the time of driving. Now, we'll get into that a little bit more. In order to do the calculation, we need information. Individual's weight, male versus female, and yes, size does matter. When did drinking start? When did it stop? The number and type of alcoholic beverages consumed, over what time period was each drink consumed, when and what food was eaten. This is the majority of information. We may go into a few other things. The problem, of course, is more often than not, the individual has no witnesses. And so it's their word against the officer, so to speak. And again, frequently they don't have a good recollection. Sometimes we don't get cases until they're over a year old, and people have a hard time remembering. And we're not here to make up anything or anything like that. But with a good case, we can show that people are under the legal limit at the time of driving. Realistically, if people are above 0.12, this defense becomes somewhat challenging. It can be done. We have successfully defended at DMV people up to a 0.27, very unusual case, obviously. More difficult for heavier individuals. Again, size does matter. Heavier individuals require more alcohol to be consumed. Heavier individuals distribute alcohol within the body differently than, shall we say, regular weight individuals. Works slightly better for females because females go to higher levels quicker than males. And that has to do with the distribution of fat in the body. Not trying to be sexist here. Again, the defense becomes somewhat difficult if you don't have corroborating witnesses. It can be relatively good if the subject told the officer what they drank during the initial interview and they stick to that. Then the jury and DMV will tend to believe the individual if there's no change in that. Before I get into questions, the biggest mistake arrestees make with respect to officers is lying to them. That's the absolute worst thing they can do. The officer will record what they say in the police report. It will be used against them at DMV. It will be used against them in trial. More often than not, they will downgrade the amount of alcohol they had. You know, I just had 4 beers at the bar, but they tell the officer they had 2 beers. We call that the 2-beer defense. They will be asked, when did they drink? They just finished the drink. They will tell the officer they finished 2 hours earlier. They don't understand how this works. So it is unfortunate, but a lot of people do that. And at DMV, without really many corroborating witnesses, it's the death sentence because the DMV officer essentially, says who are you lying to today and your history. So I guess we come to the question period. I don't know how this is handled. I'll leave it up to TASA.
Could all the attendees please type the passcode into the Q&A? And our first question is there a time limit on performing the blood test?
Say that again?
Is there a time limit on performing the blood test?
Is there a time when he has to take the blood test? No. Yes, there is. Actually, you're correct. Once a person is arrested, and if they choose a blood test, the blood test must be taken within 3 hours of driving. This also applies to the breath test. So that is one California law, and that does become an issue. I've had it as a number of cases as an issue, particularly in accidents. People's cars break down. The officer doesn't show up for an hour or two. So yes, in California, the chemical test must be taken within 3 hours of driving. And of course, it is the burden of the officer to show that that was done. I understand in some states that's 2 hours, but in California it's 3.
Okay, and how long do they have to test the sample?
To take the sample?
To test the sample.
Well, again, they have to draw the blood or breath within 3 hours of driving, period. There's a 3-hour presumption in California. The 3-hour presumption says that if the sample is taken within 3 hours of driving, then it can be assumed that that was the alcohol level at the time of driving. It is, however, a rebuttable presumption, which simply means, and unfortunately, many judges don't understand this, but what that means is that it is rebuttable, and if you present any reasonable evidence to rebut the presumption, then the presumption goes away, and the jury has to decide the case based solely on the evidence reported. However, I've actually had a judge at the end of a trial, and we presented evidence, said, oh, I'm going to invoke the 3-hour presumption, and found the individual guilty. That was wrong. But again, it's got to be taken within 3 hours. If not, then there's no presumption, and now the burden shifts to the prosecution to show what the blood alcohol level was at the time of driving. That becomes a bigger issue because now they call in their own expert who makes assumptions that may or may not be true.
Okay, and what do you do with a super high BA level, like above 0.3 or even 0.4, so assuming they're still conscious?
Well, that's a tough one. The accepted level for death is about 0.50. I've seen blood samples as high as 0.42, 0.45, and I think the highest I've ever heard of was like a 0.54. Obviously, the higher the blood alcohol level, the more difficult the case. And I would say that if you have a high blood alcohol level, one, in spite of what some attorneys would say, I would probably have the sample retested. You really don't have a lot to lose. Secondly, you have to then look very closely at what did the person have to drink? Should they have been that level based on what they had to drink? I mean, if they were sitting there drinking whiskey for 2 hours, one right after the other, and should have been a 0.35, okay, I mean, that's okay. But if their level does not correspond to what they had to drink, then you have to start looking at how the sample was handled, whether it was taken properly, mixed properly. You have to get the lab reports, look at the hematograms. Presumably that's how most blood tests are done. Make sure it was stored properly, things like that. But at those levels, you're dealing with tough cases. Now, I will tell you, and I could talk on this for an hour, but my experience over the last 35 or so years has told me that people do not register blood alcohol levels that correspond to what they had to drink. Believe it or not, I've had literally hundreds and hundreds of cases where people tell me what they had to drink, it's in the report, and their blood alcohol level makes no sense. I'm not sure why this occurs. There's a couple of reasons, and it's primarily breath. Absorptive phase error is one. There's a brand new study out of Germany that I just got that essentially the bottom line is that they maintain there is no correlation or consistent correlation between breath levels and blood levels. The one thing this study did that I've never seen before is that people drank alcohol in random order. They could drink whatever they wanted, whenever they wanted. Most studies have individuals drinking a beer every 20 minutes, a shot every 20 minutes, or something like that. In this study, they were allowed to drink whatever they wanted, whenever they wanted. It was, of course, documented. But their conclusion was blood and breath can't be correlated. That's, in my opinion, a very, very major issue. Anyway, go ahead.
And how does vomiting affect the sample for a blood test, and the breath test, and would it affect the blood test?
Vomiting should not affect the blood test. Breath tests, if the vomiting occurs within 15 minutes of the test, then under Title 17, it is not a valid test. The closer it is to the time of the test, obviously the more effect it could have on the test. And I'm assuming, of course, that there's alcohol in the individual stomach. Because if there's no alcohol in the individual stomach, then of course vomiting shouldn't have any effect at all. The problem with vomiting is that on a breath test in California, you have to take 2 breath tests. You cannot do simply one. Those breath tests have to be at least 2 minutes apart. And typically, if you have alcohol in your mouth from vomiting, and you blow a level of a 0.20, for example, and then you wait 2 minutes and blow again, it's not too common that you will actually duplicate that .20, because in those 2 minutes, the alcohol has dissipated from the mouth, and you will probably blow something lower. But again, circumstances change. That's a generalization, not always correct.
What would you do if a client tested .1 on a breath test because she, a smaller female, had one drink before leaving a bar where she works? By the time she had the blood test an hour later, it was a .07. What is the best course of action?
Well, okay. First of all, I understand the .11. It is a breath. However, if she goes from a .11 to a .07 in 1 hour, then I know the breath test has to be wrong. You do not burn off alcohol at that rate. That's 0.04% per hour. That's double the normal high-end rate of burn-off. Burn-off is 0.015 to 0.020 per hour. So with that, I would argue that the breath test is wrong, overstated it. If she had just completed drinking, I would argue absorptive phase error, and I would obviously then go on the blood test. I would look at her drinking pattern, what she had to drink and when, try to determine what she should have been, but I would argue that the breath test should be ignored because people do not burn off alcohol and go from a 1.1 to an 0.07 in 1 hour.
Okay, Stanley, we're going to continue with the presentation, but we will have another break for Q&A at the end.
That's fine. Thank you. Okay. Moving on. This is an example of a blood alcohol concentration chart that we prepare for a lot of our cases. It is generated from raw data that is inputted in our computer and run in a program, and then transferred to the graphics. The blood alcohol levels that I testify to are not taken off the chart, and I think that's important. The chart is merely an illustration of what's going on. If you look at the chart carefully, you'll see there's a dark red area and a light red area. The calculations are run at two burn-off levels, 0.015% per hour and 0.020% per hour, which is the normal burn-off range for most individuals. So if you look at the top of the chart, that's what I would expect the individual's blood alcohol level to have been over the course of that evening, from about 8:15 to 3 o'clock in the morning, at a burn-off of 0.015% per hour, or the low end of the normal range. The bottom of the dark red area represents the same calculation, but using a burn-off of 0.020% per hour, which is the high end of the normal range. So, therefore, I would expect that individual's blood alcohol level to fall somewhere within that dark red area over the course of that evening. But again, this chart is to illustrate that. Juries can relate to these charts. Now they kind of understand what's going on. They don't really understand absorption, elimination, rising alcohol, things like that. They like to see something visual. These charts have worked very, very well for us in a number of trials. And of course, they're individualized. Every chart is different. No two charts are the same. No two times are the same. But it does take into consideration all the variables that I talked about earlier. Okay. Field sobriety tests. In California, when you're stopped and arrested for drunk driving, you're charged with 23-152A, driving while under the influence of alcohol. You're also charged with 23-152B, driving with an alcohol level of 0.08 or greater. However, with respect to field sobriety tests, that is what typically is used in court to show that someone was under the influence. The public doesn't know you could be arrested for under the influence at literally any level. We've actually testified at cases as low as 0.05. The trouble with field sobriety tests is that they assume everybody's going to perform them perfectly if they had no alcohol in their system. Absolutely not. I like to have the defense attorney ask the officer, are there individuals that might have difficulty with some, if not all, of the field sobriety tests under any circumstances? Of course, they can answer yes or no. And it doesn't really matter what they answer. I don't think they can justify the answer. If they answer no, then you've got to point out that it is unreasonable to believe that everybody would perform the test perfectly. And if they answer yes, then you have to ask the officer if they know how your client would perform the test with no alcohol in their system. I like to, was the arrest based solely on the results of the FSTs, not including the past results? And the past results are probably taken about 70% of the time. What you want to show here is that the officer came to the wrong conclusion because they either did not demonstrate the test properly, perform the tests that are not reliable, or interpret the test incorrectly. We get MVARs pretty routinely, which is the video recording from the police car. And we're able to observe what officers do in many instances. Unfortunately, in many other instances, they take the subject off camera, and we don't know what's going on, and we can't see anything. But it is a rare day when I see an officer do all of the FSTs correctly on the video. Again, I could talk about that for an hour. For example, when performing the horizontal gaze nystagmus test, the stimulus is to position 12 to 15 inches from the eye. It requires actually 12 passes, I don't know why it says 8, and from 60 to 80 seconds to perform the test. This test is rarely performed properly, extremely rarely. One study watched 52 officers performing HGN tests in the field. One officer did it correct. That's our experience as well. If the tests are not done using established procedures, then under the law, they're inherently unreliable. I refer to field sobriety tests as voodoo economics. And again, we could talk about that for an hour or two. There are 3 National Highway Traffic Safety Administration standardized field sobriety tests: the horizontal gaze nystagmus, the walk and turn, and the one-leg stand. Doesn't mean that these are the tests that are routinely run by officers. It is very common for officers to run just these 3 tests, but many times they run other tests that are not standardized, such as finger to nose, finger count, hand pad. The Romberg test is a fairly common test. But the question is, what do these other tests mean? They're non-standardized. What I basically testify to is that NHTSA went out and standardized 3 tests. They looked at all of the tests, but rejected a number of them because they either couldn't be standardized or they were just unreliable. So, for example, when a person doesn't pass the finger to nose or finger count, what does it mean? What scientific studies out there tell you what it means? Females, for example, and I'm sorry, tend to be less coordinated than males. They tend to have more difficulty on these tests. This is one thing we look at on police reports. What did the officer say in his police report? Did he document it properly? Horizontal gaze nystagmus, for example, if you look at the 3 clues, is documented improperly more often than it's documented properly. It is a test that is given a lot of weight by the prosecution. It is a test that is rarely conducted properly. It takes, like I said, 60 to 70 seconds to do that test. On the average, they take about 23 seconds. They're supposed to do 12 passes. Usually they do as little as 1 or 2, as many as 4 or 5. They don't do the test properly because you have to stop the stylus at a certain position to look for sustained nystagmus. Like I said, I consider them voodoo economics. Okay, HGN, lack of smooth pursuit, distinct and sustained nystagmus at maximum deviation. This is the clue that is frequently done improperly. Onset of nystagmus to 45 degrees. How do you measure 45 degrees? Under NHTSA guidelines, there are 3 clues per eye, 6 total. You fail it if you have 4 clues or more. NHTSA claims that HGN has an accuracy of 77% to show that a person is 0.10% or greater. My studies show that people under .08, .02 to .07 actually show 4 clues over 90% of the time. Obviously in direct conflict with NHTSA studies. Walk and turn. Cannot keep their balance during instructional phase. Starts before instructions are completed. Stops while walking. Does not touch heel to toe. Can miss by ½ inch. Steps off the line. Uses arms for balance. Improper turn. Correct number of steps. 8 clues. Failed 2. In order to do the walk and turn properly, the officer has to give 9 instructions. If I gave you 9 instructions and I asked you to repeat them in 2 minutes, how many do you think you could repeat? This is an unrealistic test. Officers never tell individuals what they're not supposed to do. And in many cases, they're misleading. For example, and I'll get into it, the one-leg stand. The suspect sways while balancing. Everybody will sway doing this up to 1 inch. Uses arms for balance, over 6 inches. Opts to maintain balance and puts the foot down. 4 clues, failed 2. NHTSA claims accuracy of 65%. It's very, very common during the instructional phase for officers to tell the individual that if they put their foot down, just raise their foot and continue. Many people interpret that as it's okay to put my foot down. The trouble with these tests is you have no idea what the officer is looking for. You feel that the subject feels this is used simply for the officer. They have no idea these tests are going to be used against them in a court of law. They may not take the test that seriously. Some do, some don't. And of course, these tests are always given before Miranda. But yet they are one of the crucial pieces of evidence to use in trial. This is not right. Okay, if the officer performed non-standardized tests, those are other than the 3 standardized tests, such as Romberg, finger nose, hand pat, finger count, alphabet, etc. Ask them why they performed the non-standardized tests, and are they aware that NHTSA rejected these tests. Ask them on each of the non-standardized tests what specifically constitutes pass or fail. Will individuals with no alcohol in their system perform these tests? And are they aware of any scientific studies whatsoever that tell us what these tests mean? On the Romberg test, for example, they usually have the subject estimate 30 seconds. Rarely does the subject estimate exactly 30 seconds. If they do not estimate 30 seconds, the implication is that they are under the influence. Ask the officer what number constitutes passing, and in the CHP manual, that's plus or minus 5 seconds, by the way. And are they aware of any studies of sober individuals estimating 30 seconds? What is the average estimate of 30 seconds by sober individuals? Obviously, the objective here is to show that the officer has no information on which to judge the estimation of 30 seconds. And it's interesting. Many people come close to 30 seconds. There are 2 studies out there. One says normal people will estimate it within 5 seconds, others within 10 seconds. So if we use the 10 second, that means from 20 to 40 seconds is normal. If it's normal, the prosecution just downplays it as okay. But if it's not within those limits, they try to move it to very high levels where the individual is under the influence. All right. The specific results of field sobriety tests are not predictable in advance. They are unpredictable. You can ask any officer if they can predict how a person will perform on field sobriety tests prior to them performing the test. They will say they don't know. It's unpredictable. How do you use something that is unpredictable to predict that somebody is under the influence? The Clemson Study is one study I use frequently. Basically, they took 14 officers, 21 individuals. They had them perform field sobriety tests, and they showed the videos to the 14 officers. 5 were rated as under the influence by all 14 officers, 1 rated under the influence by all but 1 officer, 3 rated as unimpaired by all officers, 12 had mixed results. All 21 were alcohol-free. Evaluation of roadside impairment tests, Dixon, Clark, and Telepathy out of England, 122 individuals. Of those with no alcohol in their system, 47% failed the field sobriety test. Females tend to do poor, with 52% failing. HGN was observed in 21% of the alcohol-free subjects, and most of those were under age 40. The government's expert. Most government experts, and I was one at one time, have no experience with real cases. They have never interviewed a DUI subject or reviewed the police report. Everything the government expert testifies to is theoretical or based on studies. Studies may not necessarily duplicate the real world. Their prosecution witnesses have been trained by the government. They will try to use very rapid absorption times, 15 minutes, which is not supported in the literature. Very few, if any, have training on field sobriety tests and are not qualified regarding field sobriety tests. Don't let them test the field sobriety test. When I worked for the Department of Justice from 72 to 82, there was never a defense expert in a trial. They weren't around then. I could literally testify to anything I wanted, and I was frequently asked about field sobriety tests. I had done some of those, so I testified to them. Don't let their experts testify to them unless they can show that they've been properly trained. Government experts tend to use averages or numbers so they can conveniently calculate a BAC without a computer or calculator. They will use an elimination rate of 0.02, which is a high end. Using an O2 requires the subject to drink more alcohol. They will also assume that everybody is average or identical as far as alcohol is concerned. And remember, the average person is Chinese and female. They do not fully understand the impact of weight on the distribution of alcohol in the body. And it is not uncommon for them to perform many duties in the lab, and thus only a small amount of their time is actually spent on alcohol. Moreover, that time is spent analyzing samples, which has little to do with the interpretation of blood alcohol levels. They usually cannot cite any specific studies to back up their opinion. They talk in generalities. Conclusions. I think we're about right. Drunk driving and alcohol-related cases are much more complicated than most people realize. They are difficult cases to win. Due to their complexity, some juries have a hard time understanding and accepting defense issues. Juries will tend to believe the police officer, even if it can be shown that he is not accurate in some of his testimony. The jury's attitude is simple. It's okay until it happens to me. Hire an expert. Don't do this at home. You could hurt yourself. Questions?
Could all the attendees please type the passcode into the Q&A once again? Our first question is, how can a California arrestee determine what their BAC measurement was?
How can they determine it? Well, obviously, if a chemical test is taken, if it's a breath test, they might even find out right on the spot. The officer might tell them. If not, then it is obviously part of the police report, and they or their attorney is entitled to a copy of that police report. Other than that, I don't know how they're going to get the results. If they go to a DMV hearing, then they will get the results then, but they're entitled to those prior to the DMV hearing. If they request a DMV hearing, then DMV will automatically send them or their attorney discovery prior to the hearing.
What is the penalty in California if you are properly admonished regarding PAS device tests but you refuse?
Well, essentially, it's by DMV, it's a 1-year loss of license. So you lose your license for a year. There's no ability to get a temporary license or a restricted license. or anything like that, and you can still be prosecuted in court for drunk driving. They'll use the field sobriety tests or your statements or anything else. Financially, I don't know what the penalties are. I don't get involved in that. But again, DMV will take your license for a year. Now, if it's your second offense, they take it 2 years. Third offense, they take it 3 years. And on the fourth offense, it's a felony.
And what are the typical medications that could affect the breath test and or blood test?
Ooh, that's a good one. Blood test first. Not a lot of medications that I'm aware of are going to create alcohol in the system. However, certain medications like Xanax, for some reason, they tend to destroy or inhibit an enzyme in the stomach called alcohol dehydrogenase. The significance of this is that when you drink alcohol and it goes into the stomach, this enzyme breaks down some of the alcohol. And so it's not alcohol, obviously doesn't affect you. If this enzyme is inhibited, then you will have more alcohol in your stomach and subsequently more alcohol in your blood than you would normally have. Food slows down absorption. Milk products slow down absorption. Things like this. Absorption, I'm getting a little bit off the topic, has to do with what's consumed. Was it beer? Was it straight shots? Things like that. But there's not a lot of drugs that are going to create alcohol in your bloodstream. As far as breath tests are concerned, again, you want to look at the 15-minute wait, make sure nothing was in the mouth for 15 minutes. Chewing tobacco is a common one. I think one of the big problems is these inhalers. We're not really sure what they do. There's been a few studies on them, but there's nothing out there that is conclusive. You want to make sure they don't use an inhaler prior to the test or do anything else that can affect the test. But again, the Xanax can affect the breath test because you go to higher levels. There's just not a lot of chemicals or drugs that normal people take that are going to dramatically change a blood or breath alcohol level. Now, if you're diabetic, that's another issue.
And does liver damage affect the BA level, like what you find in alcoholics?
Well, that's an interesting question. For some reason, alcoholics tend to burn off alcohol at higher rates than normal individuals. Tend to. About 90% of the alcohol in the body is broken down in the liver. It's broken down to acetic acid. And if the liver is not working properly, then you would think that the alcohol would not be broken down as efficiently as normal, which means that you would stay at higher levels longer. But unfortunately, there is no scientific literature out there that I've ever seen that supports any of this or studies any of this. I have not seen somebody go out and one, find alcoholics, excuse me, and two, feed them sufficient alcohol to study this. You can't have volunteers and feed them alcohol and take them to levels of 0.25 and 0.30. That's just too dangerous. So there's not a lot out there, unfortunately.
And could you please provide the source or citation for the German study that you mentioned showing no correlation between BAC and breath AC?
Yes, I can. I have a copy of it. Let's see here. Oh, let me find it. Where is it? Where is it? I don't remember who did that. Okay. Give me a second here, sorry. Here it is. And I have a copy of it. If anybody wants a copy, I can email them. But it's called, I had it right here. Here it is. Standardized Field Sobriety Tests and Measures of Cognitive Functioning. No, that's functioning? No, that's not it. I do have it. I got so many of these things, it's hard to find them. If somebody wants to email me, I can email.
Yeah, if you just wanted to email that over to us, and then we can supply it after the webinar to everyone.
I can email it to TASA. And,
sure.
They can certainly, excuse me, in fact, okay, next question.
Is there a better field sobriety test than the HGN walk and turn or balance test?
Well, boy, that's a tough question. I don't think field sobriety tests should be used at all. I don't think they're fair for most people. Now, what I'm really referring to, and I have to be clear on this, are at relatively low levels. That's when field sobriety tests fail. At high levels, when a guy's a 0.15 or a 0.20, okay, you know, I understand. I don't have a problem with that. But at low levels, that's when these tests, I think, can be very, very, very misleading. And I don't have a good answer for this. I do, but it's something that is probably a little bit extreme. And my opinion is that they should lower, if they're going to lower the blood alcohol level, for example, to 0.05 that they're talking about, they might as well just lower it to 0. Because right now, how do you know when you're a 0.08? Can anybody tell me? No. How do you know? You don't know. Too many middle-of-the-road, average people are arrested for drunk driving innocently. They never, ever believed they were under the influence. Anyway, so I don't have a good answer to that. Actually, one answer would be to require by law that if you're stopped, that you have to submit to a preliminary alcohol screening device or pass test, chemical test. And if you blow over the legal limit, fine. That would get around these voodoo economic tests. But no, I don't have a good answer for that at all, and I don't think there is a good answer.
Will the presence of any blood in the mouth affect the breath test results?
Well, it could. You have to remember that the concentration of alcohol in the blood is 2,100 times the concentration of alcohol in the breath. So you don't have to have a lot of blood in your mouth to register a blood alcohol result. And the interesting part about that type of thing is that you would tend, if the tests were taken in a short period of time, you would tend to show the same results because the alcohol is really trapped in the blood. It's not just what we call loose. So yes, that can be an issue, definitely.
And what is the absorption phase error?
Absorption phase error is when a person consumes alcohol and the alcohol is being absorbed into their bloodstream. The alcohol goes into the blood, goes to the liver, the heart, and then the lungs. So one of the first places that blood goes is the lungs. Well, you're overloading that portion of the blood with alcohol. So you have more alcohol in that portion of the blood than in the other body parts. And as a result, your blood alcohol level can be overstated. Studies have shown this to be as much as 270%. And there are 2 or 3 studies out there. It was first studied by Simpson in 1982. And then there was a recent study out of Israel, I think in 2009 or 10. and then the guy by the name of Jagir did some studies on that. So, it has been, confirmed, and interestingly enough, if you read scientific studies on alcohol, very frequently they will state in them that the study was done in the post-absorptive state. And they're doing that obviously because they know there's a problem in the absorptive state. I just had a hung jury on a 1-2, and that was the exact issue that we had at that trial.
This is going to be our final question for today. How much variance between the two blood test results constitute grounds to dispute the breath test results?
Well, I'm not sure if I fully understand the question. Breath tests have to be within plus or minus 0.02% of one another to be acceptable. Blood tests are always analyzed in duplicate at the lab. The results of the two tests are averaged, and then the third decimal place is truncated. So, for example, if you have a 0.102 and a 106, that will be averaged to a 104, and the 4 is truncated. The reported BAC is therefore 0.10. And there is no requirement that the blood test be within a certain range of the breath test or vice versa. And so they are two independent tests. They are never done at the same time. They are always done far apart. And thus, as a result, you can't really compare one to the other.
Okay, thank you so much for answering those questions. There are additional questions that we will email over to Stanley to have them answered for all the attendees.
That's fine. And if you send me your email address, Emily, I'll send you that article.
Okay, great. In addition to being your best source for testifying and consulting experts, TASA also offers e-discovery and forensic solutions, free interactive webinars, cybersecurity services, day-in-the-life videos, and research reports on expert witnesses, such as the Challenge History Report 2.0, the Professional Sanction Search, and the Expert Profile 360. I want to take this opportunity to thank everyone for attending, and most especially Stanley Dorrance for his time and effort in creating this presentation. If you would like to speak with Mr. Dorrance, or if you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA at 1-800-523-2319. Deborah Morris, who has been sitting in on today's webinar, will be following up with you with regard to your feedback on today's presentation. Thank you again and have a great day, everyone. This concludes our program for today.